One Supreme Court ruling, four different states, four completely different legal situations right now, even though every one of them is bound by the exact same decision. Wolford versus Lopez struck down Hawaii's default consent rule for carrying on private property, but Hawaii is not actually where the most complicated part of this story is happening anymore. California, Maryland, New York, and New Jersey each built their own version of the same basic mechanism, and each one is sitting in a genuinely different legal position today, weeks after the ruling came down. If you live in one of these four states, the general national coverage of this ruling has probably not told you what actually applies to you specifically right now. Let's go state by state. Quick thing before we get into it. I track how a single Supreme Court ruling actually plays out differently across every state it touches, not just the headline version. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into each state's actual current status. Before the state-by-state breakdown, here is the one paragraph of shared background you need, since all four states built on the same underlying legal moment. After the Supreme Court's 2022 ruling in Bruin established that states could no longer simply deny concealed carry permits at their own discretion, several states pivoted to a different lever, restricting not who could get a permit, but where that permit actually functioned in practice. Hawaii, California, Maryland, New York, and New Jersey all built some version of a default consent rule for private property open to the public, presuming carriers were unwelcome unless the property owner said otherwise. The Ninth Circuit, which covers Hawaii and California, actually reviewed both of those states' laws together back in September of 2024, striking down California's stricter sign-only version as too rigid while upholding Hawaii's more flexible version, the version the Supreme Court just struck down anyway on June 25, 2026, by a 6-3 vote, finding it violated the Second and 14th Amendments regardless of its added flexibility. Let's start with California, because its legal position is the most immediately interesting of the four. Remember that the Ninth Circuit had already struck down California's specific version of this law back in September of 2024, well before the Supreme Court ever took up Wolford, finding California's sign-only consent mechanism too rigid under the same basic reasoning the Supreme Court would later apply more broadly to Hawaii's law. That means California's default consent rule was already dead at the circuit level before Wolford was even decided, and Wolford's ruling essentially confirms and reinforces a conclusion the Ninth Circuit had already reached about California specifically. If you are a business owner or a concealed carrier in California, the practical reality is that the restored default, carriers presumptively welcome unless the owner says otherwise, has actually been the operating legal environment in California for longer than in Hawaii itself, since the state-level fight there resolved earlier in the underlying litigation timeline. Maryland sits in a notably different position, and it is worth understanding exactly why. Maryland's version of this law was still active and being defended when Wolford came down, with Maryland's own case sitting at the Supreme Court's doorstep, specifically waiting on the outcome in Wolford, according to court reporting on the broader litigation landscape. Because Wolford's reasoning applies generally to any default consent mechanism structured similarly to Hawaii's, rather than being narrowly limited to Hawaii's specific statutory text, Maryland's law is now widely expected to fall as well. But as of this recording, that has not yet been formally confirmed through Maryland's own case working its way through its own court. If you are in Maryland, understand the distinction clearly. The legal writing is on the wall, but the actual formal invalidation of Maryland's specific statute requires its own separate ruling applying Wolford's reasoning to Maryland's law by name, a process that has not yet fully played out even though the outcome is widely considered close to certain. New York and New Jersey round out the group, and both present a similar picture to Maryland, active default consent laws that were not the specific subject of the Wolford decision, but that rely on legal reasoning the Supreme Court has now rejected. The Second and Third Circuits, which cover New York and New Jersey respectively, had already been narrowing versions of this scheme in the years leading up to Wolford, meaning both states arrived at this moment with some prior circuit-level skepticism already on the record, even before the Supreme Court's own ruling added a considerably stronger, nationwide precedent on top of that existing skepticism. As with Maryland, Expect each state's own specific statute to require its own case to formally strike it down, even though the practical outcome is now treated by most legal observers as effectively settled in advance of that formal step actually happening. Here is what this means practically if you live in, work in, or travel through any of these four states right now, today. In California, treat the restored default as your actual current legal environment, since that state's version of this rule was already struck down independently of Wolford and has been for close to 2 years. In Maryland, New York, and New Jersey, the underlying state law technically remains on the books as written, meaning you should not assume it has been formally struck down in your specific state simply because Wolford came down for Hawaii, even though the practical expected direction of travel is now extremely clear. If you are a business owner in any of these four states, the safest practical approach, regardless of your specific state's exact procedural status, is the same one that applies everywhere this ruling reaches. Decide your own policy actively. Communicate it through clear signage or verbal notice, and do not rely on a state default you are not certain currently applies in your specific jurisdiction, since relying on an assumption about a law's current status is exactly the kind of mistake that leads to a genuine legal dispute later. It is worth understanding why these four states, plus Hawaii, ended up being the specific group that adopted this mechanism in the first place, rather than a broader or different set of states. All five are states that, generally, already maintained more restrictive gun laws overall before Bruin, meaning the default consent approach for private property represented a continuation of an existing regulatory posture using a new legal mechanism specifically designed to survive Bruin's historical tradition test, rather than a novel approach adopted by states without any prior comparable restrictions. That shared starting point is part of why all five states' versions of this law share such a similar underlying structure. Even though the exact mechanics, sign-only versus sign or verbal or written consent, for example, varied somewhat state by state, a variation that mattered enormously in California's case specifically, since it was the stricter sign-only mechanic that got California's version struck down first, well before the broader, more flexible version Hawaii used met the same fate. There is a pattern worth naming across all four of these states, because it tells you something about how this specific fight is likely to end even before each state's individual case formally resolves. In every one of these four states, gun control advocacy organizations have responded not by contesting Wolford's reasoning or claiming these states' own versions of the law can somehow survive it, but by pivoting toward encouraging individual businesses to voluntarily post their own no firearms signage, exactly mirroring the response seen in Hawaii itself. That consistent response across all four states is itself a strong signal that even organizations opposed to this outcome are treating the eventual invalidation of all four states' laws as a foregone conclusion, focusing their remaining energy on the one tool Wolford left fully intact, individual business signage, rather than on trying to preserve the state-level default mechanism itself. Step back and look at the actual shape of this story across all five states together. A single Supreme Court ruling rarely resolves an issue instantly and uniformly across every jurisdiction it touches, even when its underlying reasoning is broad enough to control the outcome everywhere. California's fight was already over before Wolford. Hawaii's fight ended with Wolford directly. Maryland, New York, and New Jersey are each still waiting on their own specific formal resolution, even though the practical direction of that resolution is about as clear as these things get. If you live in one of these five states and you are trying to figure out your actual current legal situation, the honest answer requires knowing not just what the Supreme Court decided, but exactly where your own state's specific litigation currently stands within that broader five-state story, since treating all five as identically resolved the moment Wolford was decided would be inaccurate for 4 out of the 5. If this state-by-state breakdown helped you understand exactly where your own state actually stands right now, hit like so it reaches other people in these 5 states trying to figure out their own specific situation rather than a generic national summary, and subscribe if you have not, because I will be tracking each of these 3 remaining state cases, Maryland, New York, and New Jersey, individually as they resolve, rather than treating this as one finished story the day Wolford came down. Tell me in the comments which of these 4 remaining states you want tracked most closely, because that tells me exactly which one to prioritize as its own specific case moves toward a resolution.